Hello. Hello, my friends. Thank you so much for coming to join me, Mark Bederow, on this Friday, August 9th, 2024. It's so hard to believe that 29 years ago today, Jerry Garcia died. And if you know, you know. It's sort of like, well, for me anyway, like everyone knew where they were the day that JFK died. And I remember exactly where I was when I got the news that Jerry Garcia had passed away. It was a very, very sad day. And it makes me feel really old to think that that was 29 years ago. It's just crazy. Hello, everyone. I did a show last night. I went on The Glarer with Will. And I don't know how many of you watched it, but we had I thought it was an amazing show. And we're getting rave reviews today, by the way, on his comments. But we talked for 3.5 hours. There was never a lull in the conversation. It was all about Karen Reed and all about, oh my gosh, Terry, you're in Vegas for the shows. I was there last weekend. It was amazing. So funny. I was just watching Vinnie Politan, who I have a secret competition with on subscriber count, and he was in Vegas too. I can't wait till that rumor starts that I was in Vegas with Vinnie Politan, just like I was in Cancun with Alan Jackson, according to the twits. But it's amazing, Terry. Charge your phone up before you go because you're going to take a lot of video and it's going to kill your battery. So it's an awesome place. Yeah. So for the record, I was not in Vegas with Vinnie Politan, although I heard him just say that he was in Vegas this week too. In any event, we're back. We're here for Karen Reed at 2 p.m. I have Mark Bederow here with me, and here he is. Hello.
How you doing?
How are you?
So if you predicted suit, you win, I guess, apparently.
I heard there was a little poll in the chat about whether or not, or there was a competition. You see that Mark is in a suit, so I think you were wrong on that. I think Scott has changed his name to Albert's Bulkhead Doors, which I wholeheartedly approve. What up?
How's it going?
It's going pretty well. So for those of you who think that he's got a suit on, yeah, I think from the waist up he probably has a suit on, but I'm betting you got shorts on the bottom.
I'm definitely wearing shorts on the bottom.
It's a
It's
Zoom
still
day.
summer and hot, so yeah.
Oh, you're glitch. Is it me that's glitchy, or is it you that's glitchy?
I'm not going to stand
I
up.
can't tell. Oh wait,
I don't know. Is it me?
do you have headphones on? I think I'm coming.
I do not have it.
Okay, if I'm coming through your laptop speakers, maybe it's feeding back in.
I'm not sure.
But that's the way you normally do it, right? So we should be fine.
Yep.
This is interesting. I wanted to show this to you because this is something that you and I have both been talking about. And shocked, not shocked. This was on Boston 10 last night. Take a listen.
Now only on NBC 10 Boston. More fallout from state police trooper Michael Proctor after his damning testimony in the Karen Reed murder trial. Proctor is currently suspended without pay and under an internal investigation. Our Kirsten Clavin joining us live in the newsroom to explain how this is now affecting the other cases he's worked on.
Yeah, Priscilla, that's right. In legal terms, it's called a Brady letter. And we're now learning 13 separate attorneys have been contacted by the district attorney's office about how Trooper Michael Proctor's conduct could now be brought up in their own cases. In new documents obtained exclusively by NBC 10 Boston, this letter shows the Norfolk County District Attorney's Office has contacted more than a dozen criminal defense attorneys whose cases all involve investigations done by State Police Trooper Michael Proctor. It states that Proctor has been subject to cross-examination regarding issues like conflict of interest and bias, adding that he's under investigation and suspended without pay. All of this following the high-profile Karen Reed murder trial.
Anytime the government is trying to use a witness with this kind of baggage, it will call into question his credibility and whether or not proper procedures were followed.
Joseph Cataldo is one of these lawyers who received the letter. His client was indicted in connection to a July 4th murder in Randolph last year.
I don't know what the Commonwealth is going to do with these witnesses, but I know that we'll be filing more motions.
Other cases likely impacted by Proctor's involvement include a prominent doctor in Dover accused of killing his wife back in 2020, the murder of a moped driver in Milton from 2021, and a child.
Nope.
I just swipe myself out. Sometimes that happens. It's a thing with the StreamYard, and they shouldn't allow that to happen. But I'm back, and I didn't miss a beat because I stopped that video right as soon as I did. So here we go. This is crazy, but it's like my favorite thing to say is "I told you so," and I did say "I told you so" about this. So it's only like another minute.
Back in June as the lead investigator reading his graphic text messages aloud to the courtroom.
From all accounts, he didn't do anything wrong. She's a whack job.
An unofficial transcript of his testimony in this case also sent out to attorneys from these other open cases.
I'm sure there are going to be a lot of defense.
Wait a second. They said these other open cases, and they've got, look, Alan Jackson, Elizabeth Little, David Yannetti. I mean, they have other cases with Proctor in it too. It's like, okay.
Weinberg. They've got 4
And
lawyers.
Weinberg.
This alone, yeah.
I think I'll call each one of these Kevin Reddington, see who wants to come on the show and talk about it. All right. Excellent. Excellent show idea right there. Thank you, Boston 10.
Sent out to attorneys from these other open cases.
I'm sure there are going to be a lot of defense lawyers thinking of really creative ways to try to convince a judge that all this information that happened in the Reed case should be held against Trooper Proctor in any case he was a lead investigator on.
Law experts say these select attorneys will likely file additional motions to get more information on his background.
Even looking forward to the second Karen Reed trial. What are they going to do with him as a witness in that case now that all this is out there? Are they going to call him again? Are they going to not call him? Are they going to, who knows? It may impact how they have to proceed in the second Karen Reed trial as well.
And on that note, Karen Reed does have another hearing tomorrow where the judge will hear arguments to have at least 2 of the 3 charges dropped in her high-profile murder case. Live here in the newsroom tonight, I'm Kirsten Glavin, NBC 10 Boston.
Yes, so many questions as to how that's going to affect other cases. Kirsten, thank you.
I mean, if you were, admitted in Massachusetts right now and you had a client or two that was sitting in prison because of an investigation that was handled by Proctor, what would you be doing right now?
You would be sending demands for much more than the milquetoast disclosure that the Norfolk DA made, which was just, maybe there's something with him. We're notifying you under Brady and Giglio, which is just credibility that they have to disclose, but you're going to want specifics. So what I would do and have done in many cases, what other lawyers almost certainly are going to do, is demand much more information, honing in exactly with what Proctor did here. And they're going to focus on the fact that his ridiculous testimony, if you recall, was I just got emotional and I lost myself. And that's why I did this. Now, putting aside the fact that that's totally false, that's perjury, that's nonsense. If you take that at face value, then it leads one to believe that he might have done that in other cases, in murder cases, which might have been much more emotionally impactful to a law enforcement officer than a hit and run, not to minimize what happened to John O'Keefe.
Right.
But if this case caused him so much emotional harm, then did he text message his family, his other state troopers, and others in those other cases? And this letter is only about Proctor. But what lawyers are going to do is, well, I want to know about Buchanan because they're peas in a pod on their
Right.
cases. And he's mixed up in this. And their supervisor is Tully. He's mixed up on this. We know they're both under investigation for something which may or may not be related to Karen Reed. So this disclosure, although required, is entirely unsatisfactory to what the lawyers are. And then you have other cases, which I want to be very careful not to get into a specific other Massachusetts case, which I've become much more familiar with recently. And in that case, which we won't talk about specifics, but there is public information available in a certain witness intimidation case that Michael Proctor is an actual alleged victim in that case, not even just an investigator. He is an alleged
Wow.
victim of witness intimidation. Therefore, his credibility could not be of any greater importance than someone who's allegedly being harassed. And if he has a motive, bias, or other credibility damaging reason to favor the prosecution and possibly perjure himself or do anything else, those things are going to have to be disclosed in those types of cases as well. Same with Buchanan, who is also a witness in that case,
Mm-hmm.
victim, and other investigators. So this is just the tip of the iceberg. This was always going to be something that had to happen, under Brady. They were going to have to disclose this, but the wheels are falling off the Proctor bus. This is no surprise. And he may very well have damaged, as well as other very serious prosecutions. It really depends on what role he played in those cases. But this is a disaster that's going to follow the Norfolk DA's office around for a long time. Probably is going to lead to that homicide unit of the state police that's encamped in that office being, I would think it's just going to have to be disbanded as well. It's
Mm-hmm.
a complete disaster.
Yeah, that answers maybe Dewey's question, who says, is it a Brady rule that the DA has to reach out to defense attorneys?
Yeah, I mean, they have an affirmative obligation when they are aware of exculpatory or favorable information that would favor the defense, and the credibility of a police officer being in shatters, whether it just be an internal affairs investigation, alleged perjury, alleged bias, other kinds of improper conduct. And, of course, in this case, Proctor checks off every box of possible misconduct. I mean, he's just the worst police officer witness imaginable. He's poison at this point. Yeah, that has to be disclosed. But again, the lawyers, they're not going to settle for this.
No.
Where are the disclosures about, Buchanan, Tully, potentially others, and more specific information about Proctor? I mean, what lawyer is not going to send a letter and say, has he done these text messages in any other case? And if so, does that include mine? And what did he say?
Yeah.
I mean, don't forget, he was in this case, some of those text messages are revolving about receiving gifts for his family as
Mm-hmm.
part of the investigation. I mean, that's per se corruption. He's a
Right.
public official arranging for his family to get gifts in exchange for his what's supposed to be honest services as a police officer. So this letter is the beginning, not the end of this.
And it's interesting that they attached the transcript of his testimony too. It's like, here you go. Here's the transcript. You don't
Yeah,
even need to go pay for it or buy it yourself. We're just going to
yeah.
give it
I
to
mean,
you.
they kind of have to. I mean, they have to show what it is. Although I think in their letter they said this is the unofficial transcript, but we're going to be getting the real one soon, and we'll send that to you. And that more of this is coming because, I mean, look at the letter that they somehow released to the press. It's a form letter that's like, insert defendant here, insert. Right. So, the Proctor letter is literally written and they're just waiting for the next one to insert defense counsel name and address and docket number of each defendant there. So
It's what I call a
disaster.
scratch and sniff, right? So you have some motions like that too. It's just change the name, the dates, the
Yeah.
police officers or whatever. And
Yeah.
it's your scratch and sniff letter.
This news story and these letters that are going out, this is not exactly going to help the Proctor family campaign of, rallying the governor and the colonel to prevent this, horrible injustice that's occurring to Michael Proctor. And I mean, you saw the list of cases that he potentially damaged, murder case after murder case. They didn't even mention the Brian Walsh one that the comment talking
He
about
says,
now,
yeah,
which is a hideous case. This guy is prosecutorial poison. He's
it's a big problem. It's a big
killed.
problem because, does logic dictate that he only did it in this case, perhaps? Or is this not his first rodeo with regard to this kind of stuff? And it begs the question, like, why was he willing to risk his entire career on
I
the
don't
John O'Keefe murder case? Why?
I don't know. I don't know why he testified. If you recall, I would have advised him to take the fifth. If nothing
Mhm.
else, he would have kept his pay a lot longer, may have delayed a lot of this and maybe worked out an exit strategy. It would have kept potential cooperation better on the table for him. I mean, if he's cooperating now, which I don't know whether he is or isn't, his deal is going to be much worse if he is, because he perjured himself, in the Karen Reed case, which makes him get punished more. And also, if he does cooperate, he has damaged his credibility substantially by his testimony in the state case, because he would be admitting that that's a lie. And the other lawyers would just eat him for lunch about, you can't believe anything this guy says. So to say that he has destroyed what little of a career he probably had a couple of months ago is insane. And of course, he's completely damaged the Norfolk DA's office as well, because they vouched for him. I mean, they put him on and presented this ridiculous explanation of his, this attempt to say that he was just feeling a little emotionally upset about this horrible murder case. I mean, this is what he does for a living.
Hmm.
This upsets him that he's
Right.
not qualified, he's not stable, he's not mature, he's not dignified. He should just find something else to do, which, I don't know that he's going to be able to do that at this point. He's, become the poster child of the corruption in this case. So
The
that's
way you explained that too, the text messages, yes, that was unprofessional, but it was my personal phone, and that doesn't mean that there was no integrity in the investigation. Like,
um y- well, the problem with that, of course, we'll start with the excuse that this is his personal phone.
hmm,
Give me a break.
oops, didn't think you'd get it.
That's just, yeah, that makes it okay that, I didn't use my government phone. I mean, I guess that makes you better than Higgins with his phone, but that doesn't really matter. But also, when he says, I'm just, a pig as a human being, I don't mean as a disparaging police officer, but because I said these terrible things about Karen Reed's physical health and wished that she killed herself and all of those things. Um, from a legal standpoint, when he says it didn't affect the integrity of the investigation, they tried to basically intimidate the medical examiner to change her opinion in order to support what they wanted to do vis-a-vis bring a murder prosecution, which is also, that goes to the heart of the integrity of a police officer, trying to intimidate her or influence her scientific determinations because you've decided that this is a murder case. So that argument that they made is also just not true. It's a disaster on every level.
It was not scripted well enough.
No,
It just came across as being really ignorant, callous. I mean, unprofessional. Is that the best that he could say about? Is that the worst thing he could say about his text messages? Just I. I mean, if
he,
you were his attorney, well, you said you would have advised him
I,
not to
if
testify
I,
at all because there's
yeah,
there's no good testimony in that
no,
situation.
nothing he could say is going to keep his job. He may get himself in trouble, whether it be with the feds or anything else. And if nothing else, if you want to be selfish, the longer you keep quiet, the harder it is for them to discipline you. The longer you're going, you have a very strong union, the longer you get paid. And in the meantime,
Mhm.
find something else to do with your life. But taking this position that I did nothing wrong and not even, and if you're going to testify, my God, man, apologize. Look at
Right.
her and say, I think you're guilty of murder, but I shouldn't have done that. And I apologize. He didn't do that.
Nope.
Him and Lally looked like they were just looking at each other with their heads down, kicking the dirt, in the field and just kind of looking sheepish, having no sincere remorse, and then trying to justify it as emotionally upset. And it was a personal phone and, it's regrettable.
Oh,
It's kind of worse than regrettable.
I
And
think so.
the optics too, as he goes forward again in other cases, if he claims he's harassed as a witness, um, how are people going to feel about that and say, well, look what you said about Karen Reed. Now, she didn't know at the time because, it wasn't meant to be shared. But, if you and your cop buddies are laughing about looking for nudes and we didn't find anybody and how much you hate, Yanetti's retarded client. I mean, that word
Right.
alone, like, my God, as a police officer, is disturbing, right? I mean, they deal with mentally ill people or people that are having mental
Yeah.
health crises, and look how they talk about people privately. He's just gross.
Yeah, I think that's probably the best word to
Yeah.
describe him. He's repulsive.
Yeah.
and anything that he ever touched is now tainted, and
Yeah.
it's gonna be a huge problem in that county. And is that
Huge.
huge? All right,
And
let's take a
yeah.
go ahead. Keep going.
No, go ahead. That's it. That's
No, I was keep talking because I'm just gonna put on there's video of Karen walking into the courthouse. Everyone is really excited about her outfit today. So I just want to show it to everybody while you keep talking.
okay.
I'll play this without sound
No, it's
because I
okay.
don't think they're talking
Now
about it.
I'm curious to see what's going on out
It's
on the
Tom
street.
CPU here. Let's see.
Here they go.
So it looks like David
Showtime.
and
What are you
Marty.
getting on it?
Right?
Everybody. Nice.
Turn off the sound. David and Marty and Karen, her pantsuit is fire today. Love it.
It's a very summery look.
Yes, I like the baby blue. And
Okay.
I like the fact that it looks like she has bodyguards and she needs them.
There's a lot of lunatics, as
Oh.
you know all too well. A lot of lunatics.
Yeah, all too well. That's a Taylor Swift reference. I bet you didn't even know that.
I didn't even know that.
3 of her concerts just got canceled in Vienna because of it. They thwarted an ISIS attack. Like, it's insane.
It's crazy. And that's a week or two after that horrible thing in England with those girls who were just dancing to her music. And
Yes.
terrible.
That's crazy. Well, she does look pretty today. Very pretty. Lovely. What do you think's going to happen today? That's the question of the day.
You know, we should probably get out of the business of predicting too much with this case. I mean, and anytime something ought to be A, in this case, it turns out to be B, and vice versa. I know what I think should happen. What I think should happen is the judge should authorize the taking of more evidence and not decide it today, but kind of advance it to the next stage. Whether that means allowing permission to question jurors, to have
Oh, the sound is up.
and we're back in the little courtroom. Unbelievable.
Wait, so this is the courtroom that we were in when we went to court,
This is the
right?
closet, the back in the closet.
I'll just mute it until.
They really don't want the public in there, do they? I mean,
No, they really don't. Why can't this be in that big courtroom they had originally? Or even remember the courtroom we were on the first floor when we were waiting to go upstairs? That was even bigger.
Yep.
And the courtroom that they were in last time for the last hearing was a different courtroom altogether. It was a very tiny room.
Yep. Yep.
Somebody will have this up on Twitter soon with exactly what she's wearing and exactly how much it costs, as if to shame her for having money to be able to buy a nice suit, which if there's a retrial, she's not going to have much more left after that, which
It is a nice suit.
disgusting. Gorgeous. Looks gorgeous. I'm not sure. Is that Meredith? Is that Aiden's girlfriend? In the pink?
I think that is.
Let's see who's there for media. I don't really see anybody that I recognize right now. Oh, that's on the right. Isn't that Matt from Court TV, I think? And that's Christina Rex, I think, right there where my cursor is. Don't break your TV. That's my cursor. There's our favorite court not court reporter, court officer who likes to say, "God save the Commonwealth."
Yes.
I have missed the fan, Mark. I have to say that I really have I've missed that fan. And we got so used to sitting here every single day talking about this every single day that I'm kind of like lost. I don't know what to cover next. I don't know I just covered another horrible trial involving domestic violence for Ashley Benefield, and that was a horrible case.
Yeah,
but
that was bad.
It was a murder 2 case that they tried in like 6 days. I mean, it was so fast. And it was full days every day. It was so different from this case where we had summer Fridays and clam bake Tuesdays and happy hour Wednesdays and days off That's Mr. and Mrs. Reed, for those of you who don't know, who Mark and I had the pleasure of meeting and sitting with, who are really 2 of the nicest people I've ever met in my life.
People you'll ever meet. They really are.
So kind and warm. And you know, you get a vibe about people, like they just have such a great vibe.
Yep. So what the DA should do today, I'm sure they won't do today. They should cut this off at the pass and say, we're not proceeding on a murder charge. And then you don't have to deal with all of this. And then they can actually look credible, avoid all this juror stuff, and also avoid the risk of at a retrial, all the future jurors, they're all watching. Everybody knows what's going on. And they're going to know that, practically speaking, forget the law, she was acquitted of the murder charge. I mean, does anybody not believe that as a factual analysis, that the jurors all agreed that the murder case stinks and that she should have been not guilty? Why they didn't check off the box, whatever. All that's wonderful. But can you imagine retrying her on a murder charge and picking a jury, and they're all looking at each other saying, well, wait a minute, didn't she get acquitted of this? I mean, the lack of credibility the DA would have in that situation would be awful. So that's what they should do today. I don't think it's in their DNA to do it.
Right.
Certainly today, I think eventually they will, but they could have cut this whole hearing off, I think, just by doing that. Go forward with a manslaughter case if that's what you really want to do. I don't think they should do that either, but at least that's, given what the first jury did, at least a credible position based on the result as it was reported, and all sides appear to agree that there was, quite a few jurors who, for the time being, thought at least one of those lesser included offenses on the manslaughter was not ridiculous. But that's what I would do if I were them.
And you were a prosecutor.
I was. And again, credibility is your most important asset. I mean, you have to look at the jury and tell them with a straight face what you want them to do. And I just can't believe that they're going to take a position where they're going to argue that, notwithstanding what all these jurors are saying, it doesn't matter.
Right. Well, we got 4, I think, at least 4 or 5, and then there's a juror doe, so we don't know how many. My opinion has been that she should call them in. She should call them in. Calling them in just to ask them whether or not they reached a consensus on 1 and 3. It's not going into the inner workings of the jury. It's basically a poll, which she should have done to begin with. That's her obligation, not the defense attorney's obligation. One more thing I wanted to say that I pointed out last night is that, the Commonwealth's latest, what they're calling like a notice of discovery, like they didn't even call it a reply. They admit that 3 jurors emailed them and that they replied to those jurors on the 16th of July. They do not say when they received those emails. And I got a big problem because their response on July 12th
was very,
said that they thought that that this whole petition has no merit or foundation. Basically, it's frivolous. It's not even true. And if those emails were received before July 12th, I think they perpetrated a fraud on the court. And I think as an officer of a court, that's a big problem for them. What say you?
If the timeline fits, as you just said, I agree. I think that would be highly problematic to say something is unfounded when that's factually not true. You may think legally there's a reason to disagree, but clearly there is ample evidence, whether you find it, compelling or not, that a number of jurors have indicated we acquitted. But I guess here we go.
Right. That's a problem for them, I think. They were being a bit just disingenuous if those emails came first. I don't like it.
If they came first, a lot disingenuous.
One more problem for them. And it's easy to prove when those emails came, and I hope they bring that up today.
A lot of sticky notes in Mr. Weinberg's file there.
This is going to be great. This is going to be like seeing an OG. Like, he's one of the best appellate attorneys in Massachusetts, right? I mean, that's what my research showed.
We'll see how long this goes and how much. I mean, I don't know why they're doing argument. I mean, I think she ought to just be saying there's a quantum of proof that supports taking testimony, and let's go from there. So,
well, it's not under the rules, Mr. Weinberg. This is not how we do it in Massachusetts. Mr. Weinberg, that we cannot call the jury back. They've already been discharged, Mr. Weinberg. We'll see. What's the over-under on how long this takes? Half hour? Let's go with 30 minutes or less. Or more. Over, under 30.
It ought to be more. I think it'll be less.
Oof. Yeah, I don't even know if I would take that bet.
I mean, if you're having real oral argument in terms of what we're doing here, it ought to be more. To me, though, this is just, you order a hearing. This is a no-brainer. You just order a hearing. You can make all the legal arguments after you get the evidence, but let's find out why the jury says what they say and why they didn't publish the verdict. Here we go.
All right, if you're watching this on another stream, you might be a couple seconds ahead, so please no spoilers in the chat. We can't slow the chat. If you'd like to slow it yourself, you can just put your finger on it and it will slow it for you. But it messes with the algorithm, so we like the stream to get out there so people know where to find us. It will get louder as they find the microphones. God save the Commonwealth. Here comes the judge. Here comes the judge. He comes. I wonder if she'll swing her glasses today.
All parties having anything to do before the Honorable First Justice Beverly Canoni, now sitting in the Norfolk Superior Court within Florida County and Norfolk, Rodney, if you pretend shall be heard. God save the Commonwealth and the Court, and you may see the court now in session.
Judge 22-117, Bederow versus Karen Reed. So identify themselves, starting with the comment. Yeah, familiar with the library on behalf of Karen Reed, who sits to my left, and co-counsel David.
Good afternoon, Mr. Lambert. Good afternoon, Mr. Manning. Good afternoon, Mr. All right, Mr. Lambert, I will hear you on your motion.
Thank you, Your Honor. May I use the podium? Thank you.
Yes, please find the microphone.
Yes. God, the acoustics are so bad in there.
So bad. Law and Crime doesn't even have it up yet, so I'm looking for better volume, but I can't find it.
Judge, there are two central issues. There's not one for amplification, there's one for recording.
She's going to have to turn off the air conditioning. Law and Crime does not have their camera up. Let me just see if who else carries it. Boston 25.
She's like a buzzkill before it even starts.
She really is. Like it's. I heard it's really humid there today, and they're gonna turn off the air conditioning. I mean, tell me if the audio is better on here. I don't think so, though.
Judge, there are two central issues. There's not one for amplification, there's one for recording.
I just want to make sure I hear it.
At a day like this, I'll keep my voice.
Okay.
I mean, is that any better?
There are two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the three-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even one, much less 12 jurors in trial one. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this.
Ask for a hearing is what you do.
Transform representations in attorney affidavits into hard proof that we believe will convince the court and in fact believe.
That's asking for a hearing is what he's setting up for.
That that jury, the jury that Your Honor described as an extraordinary jury, reached a decision that will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2 and lesser included. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history.
All right, let me switch to NBC 10. People said that this volume is better. Tell me if this is better. We'll take it back. I'm only hearing it in one ear. No, it's all sucky. What is the deal, man? Why can't they get their act together? Hold on. Sometimes law and crime is better. Doesn't matter. It's probably not going to be that long. So let's see.
They're saying keep yours. It's better.
Yeah, this one. Keep this one.
That's
All
what they
right.
s-
And it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to two constructions. One, that their impasse covered all three counts, and therefore would lead reluctantly to a mistrial declaration. Or two, that the impasse was on one count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court. Neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such a historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point that came.
All right, hold on. First of all, if you're in my chat and you're redirecting to other channels, that's like super rude. So don't do that because you will be deleted. Secondly, let's go back to this one because I think Core TV fixed it. Just take it back a second. I think this is better now. And also, at least we can put the closed captions on.
In fact, it will convince Mr. Lally and the district attorney's
Better?
office that
Yeah.
that jury, the jury that Your Honor described as an extraordinary jury, reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2 of the lesser included manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts, and therefore would lead reluctantly to a mistrial declaration, or two, that the impasse was on one count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court. Neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such a historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. The second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here what we know is that 4 jurors reached out to defense counsel. Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't announce it. Some said we felt bad about it. We didn't know what to do. But they were internally consistent and not self-contradictory. And that makes them more trustworthy. They corroborate each other. And I contend that the voicemail left on Mr. Lowry's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of 1 juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not, represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this for 52 years, and the procedures important and form sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I will get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call the central proposition, which is, where's the default? Is the default from not asking the jury about these other counts that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, and I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice. And it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Mapp v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a in a world where we have facts not known on July 1 that are known on August 8. And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these two jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago in a case dealing with a lawyer's allegation that there had been a racial statement. It's called the McCallum case, 485-90. It said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before in order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during, that the jurors accessed the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can test that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because
That's it.
in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations,
Bring in the jurors.
cannot accept them because they're not the sworn affidavits of lawyers, of the jurors. Sorry, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyer's affidavits and affirm that they're accurate, or alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. Your Honor could schedule the hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure if legally you would, but to keep this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors and an independent. What I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence it was not, to establish a procedure consistent with McCollum, consistent with Tsarnaev, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from an improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Bluford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, that she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps through many years of doing this, that acquittals count. If she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be re-prosecuted. So let me switch from the acquittal and its implications to manifest.
Okay, this was my transition. So now I have an excellent transition over to this screen, which I think has way better volume. So tell me.
Acquittal implications to manifest necessity. In this case, we have explicit guidelines, which have been set out by the Supreme Judicial Court.
Okay, I just want to pause to say, first of all, I think the volume is way better over here. Thank you, whoever told me that Boston 5 had better volume. But look at the way she's looking at him and tell me that somebody is not going to make a video of this. Just like when she was looking at the Crash Daddy, and I was like, with the music in the background, swinging the glasses. All right, whoever's made that last video, here you go. Make this one too.
That look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly, and whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. And here at minimum, with 4 or 5 jurors saying, we believed her to be innocent, and we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. And I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, and is one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass. 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nickel decision because it's the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this is in fact a rule of criminal procedure, and the defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6. But They didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant, make them go to trial a second time in the face of double jeopardy's manifest necessity requirement? Or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser included. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we have 3 counts, not 1. And Rule 27B that you were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on.
Everyone just turn your volume down for a second in case I'm super loud. But Mark, this is exactly what you and I were talking about when we were watching the verdict live. And you said to me, I remember, you said, okay, she's declaring a mistrial, but now we need to know whether they acquitted on any of the charges. And we waited, and it just didn't happen.
Nope. I'm making notes, and I just love all of this.
Yeah, I mean, he's somebody says here, thank you, Mary, for your super chat. And somebody says here also, motion to refer to Weinberg as Justice Daddy. I'll allow it.
Yeah, granted.
Allow it. Right?
Yeah.
I mean, we stop, we comment. It's okay. We're a little behind anyway. So if you have any thoughts that you want to share right now.
I mean, I'll hold them for mostly till
Okay.
after, but this is everything that, we thought in real time and beyond.
Yeah.
And he's nailing it. And what he did real quickly, because I don't want to keep the delay too long, put the pressure on the DA saying justice requires that you agree with us if there was an acquittal. And he did it gently, politely, but he took the moral high ground and is challenging them to hold his hand and join him on the right side of this. And that really is brilliant.
I'm getting chills.
This is great. But
his vibe is gentle, yet firm, yet we need to be fair. Join with me in being fair and looking for justice. And I'm loving this so much. All right, let's keep going.
That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, but provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives, and we contend respectfully for a variety of reasons that neither of those two guiding principles were met by the evidence of what occurred on July 1, where we have the chronology of Your Honor taking argument from counsel regarding the first
Politely
warning
saying
note.
he screwed up.
And the
Say what?
He's politely saying, Your Honor, he's screwed up, but very delicately.
Exactly. You must. I'm sorry, Your Honor, but you must, and you didn't.
Right.
And it says right here, you must.
prosecutor didn't want a two-week instruction. Defense counsel did. Your Honor elected to give a two-week instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And
That's right. She didn't give them an opportunity to consult with their client. She just granted that mistrial. Like she was just done.
I can't wait to
there's this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing a judge's not providing an instruction that later they learn. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, Nicole, the appeals court in a case, Commonwealth versus Oregon, we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying a mistrial rests on the prosecutor. And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised your judge. So this was...
They're all idiots, Joe. That's what he said.
A case
Right.
that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria, a full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors got strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse,
This.
we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, the centrality of double jeopardy. Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. And Ms. Reed was acquitted. Bring the jurors to the judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
Did he say thank you? It's the right thing to do, or I beg you, it's the right thing to do?
Thank you. It's the right
Oh,
thing.
I just want to hear that again because I thought he said I beg you. I was like, no, don't beg. Just this is the right. Oh, okay.
Thank you very much. The burden of production. And Ms. Reed was acquitted. Bring the jurors to the judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
Well done.
Wherever you.
Yeah, don't stand. He should not be standing in front of the defense giving his argument. If he does not go back to that podium, that is a complete lack of respect. He should not be able to stand up there and look at mommy the whole time.
Why is McLaughlin even there? Isn't she supposed to be the law guy? You'd think this would be her moment. But
Oh, she's not. She's not there, is she?
No, she's there, but Lally is going to do it. Apparently staring at the table 2 feet from the judge with the defense having a view of his back of his head. Okay.
Right. Or his ass. It's ridiculous. Oh, no. He'll go back. Good.
That's better.
Be a big boy. Put your big boy pants on. Find the microphone.
Your Honor, Commonwealth would ask, request that the defendant's motion to dismiss be denied, as it was not a verdict determined. Counsel had more than adequate opportunity to be heard and object to the declaration of mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury who has declared repeatedly to the court that they're in an impasse. So simply put, Rule 27B just does not apply. When it comes to each of those respective points, the jury in this case, when one did not return a verdict, and two, counsel had adequate and ample opportunity to object to the declaration of mistrial, and three, that the mistrial was declared out of clear manifest necessity, which the court, the case law has repeatedly stated is the prototypical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries. Does quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case fit into the precedent. There's a reason for that, because there's clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's a case in which following jury deliberations and defendant having
The crinkling papers, the lack of volume. I checked Law and Crime. It's 10 times worse than this. Twisting logic into a pretzel. And now he's going to talk about a case that you disagree is on point. I take it.
Well, juvenile is the one where they found the slips on the floor where they had, reached a verdict, but they were never, nothing else indicated that they had, reached a verdict. And you don't know the timing of when those slips were on the floor. This is nothing at all like that. Nothing at all.
Buffoon comes to mind. Here we go.
been convicted after trial. One of the court officers found a verdict slip in the jury deliberation in which the verdict slip was marked not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in the report that they were deadlocked, that does not.
Because they could have deliberated after he filled out the slip. That's not what happened here.
Right.
Of the verdict as it is applied in the report. Quoting from that case, and I think it's directly applicable to what's been provided to the court so far. It states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were control, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is in contravention to that case law, in juvenile, in Bluetooth, in Roth, in Gray, In all of the cases over the decades,
This is
in
embarrassing.
dealing with this, Blueford itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes from Commonwealth versus Coroner as well.
We've talked about Bluford before and why it doesn't apply, right?
Same thing.
Yeah.
In Buford, they went back and deliberated further. So how do you know the final word was the verdict? In this case, the judge shut down deliberations and the jurors are saying we had a final determination at the end, or some of them are saying at the end of the deliberations. This is embarrassing. And again, I can save most of this for after, but they have no regard for the fact that as a minister of justice, they're telling you this is what we did. And he's completely disinterested in even addressing that fact. It's wah. We don't know. And these cases that are not on point stand for what we think. And you should just disregard this. And, you know, we should be able to try her twice for murder when she probably got acquitted. And it's his demeanor again, you know, staring at the table, mumbling. I can't with this guy, but I guess
It's like, do they want justice or do they just want a conviction? Like,
No.
really, do we really want justice? Isn't that what this country is built on? Isn't that why we have a constitution?
No, what he's basically saying is that it doesn't matter that she may very well have been acquitted because there are cases which are not on point, actually, which say that we're not equipped to deal with these kinds of issues. And again, we say this all the time about this office. Whenever they should turn left, they turn right. Whenever they should turn right, they turn left. Read the room, man. You've got to have some concern that all the jurors are telling you, or not all, a fair amount of jurors are telling you
At least a third.
that we acquitted her, and pretend to care. Even if you want to make your legal arguments, pretend to care that that's a serious thing.
Yeah.
And the position of that office is it's all meaningless.
It's insulting to the people of Massachusetts.
Your jurors are just going to crush them on this, and they're going to end up dismissing the murder charge anyway. They just have no instinct on how to handle things. It's sad, but anyway.
Here we go. More lally.
Well, what it states, Your Honor, this jury was instructed. Not only instructed orally for a lengthy time, but was provided with written copies of those instructions.
They're stupid, Your Honor. Too bad.
Stated on at least 9.
And she said in her instructions, and if what I tell you in my verbal instructions conflicts with the written instructions, you are to go by my verbal instructions.
9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to report that unanimous verdict. And there was no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked. Neither was checked. Neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was saying, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system.
What does that suggest?
These jurors,
Yeah, that this case isn't special. This case isn't. How about if there are no cases on point, Mr. Lally, because you can't find any cases on point, it is time to make new law. How about that?
He's playing the righteous, don't give her the privileged defendant excuse to get what she wants because she can bring in the big guns.
Mm-hmm.
That's disgraceful.
Despite the fact of the breaking news that every case that Proctor ever touched, they had to send a Brady letter on and notify everyone, send a copy of his transcript. Like, dude, exactly. Read the room.
Meanwhile, the jurors are watching this, whether they should be or shouldn't be. I mean, they're not under any prohibition. Nope. And they're watching the prosecutor tell the judge that a principal part of his argument is they're too stupid to credit.
Right.
That's what he's saying. They didn't check a box. So if they're telling you this, they're morons. And all that's going to do is have them talk to the press even more.
Please, I hope they do.
More negative attention. And all the defense was doing is exactly what I hoped they would do, is say, Judge, bring them in. Let's get to the facts, and then we'll go from there. And they just have no interest in having any concern whatsoever about somebody possibly being retried twice for the same crime in which they were acquitted at the first trial, which doesn't occur when you're outside of Stalin's Soviet Union, or it's not supposed to.
Right. And she told the jurors several times, do not come back to me until you have reached a unanimous decision on all counts. Right? These are lay people. They don't understand what that means.
The lack of self-awareness in this DA's office it's stunning to me, that they just have no ability to read the room at all.
It's not a smart thing to do, to be insulting the jurors now, because if any of you are in the chat, call me. I'll keep you anonymous.
And
it's insane.
Future jurors are watching right now. They're going to be familiar with all of this. When you try straight face to say that we're going to try to re-prosecute her on a murder case, which, by the way, they're not going to do, which makes this whole episode that much more disingenuous. You know, I know, and everybody watching knows, they're not retrying her for murder. They may retry her for manslaughter. They shouldn't. There is no way they're going to retry her for murder. No chance. Why would
you think they'll just drop it? I don't know. Yes. I think there's so much ego involved that they won't. Well, let's hear what else nonsense he has to say, and then we'll debate that after.
As the court referred to him as an extraordinary juror. And I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted to them, which Commonwealth would submit were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they reached an impasse as far as their deliberations were concerned, as it pertains to the charges. In the final note that was submitted to the court, they refer to the charges in the plurality, twice within that note, as it pertains to exactly what they were stuck. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional.
Doesn't matter.
You knew this
was about how those things have formulated in their minds.
It doesn't matter. The question is, what was your decision in the room? It doesn't matter how much YouTube they've watched since then, right?
Don't do this now, Judge, because since the trial's over, you know, they've learned things that probably reaffirm the acquittal, which is that she got screwed and the case is worse than they knew when they acquitted her.
And he's actually submitting that they're going to come in and lie under oath. They're going to commit perjury because of things that they saw on the Twitter and the Facebook and the YouTube. Come on, dude.
The DA is putting the judge in a bad position too, because if they punt on the murder case, they keep her from having to make a real tough decision. And when they go all in, like they are, they're putting this squarely on the judge to do the right thing. So that's going to piss her off too. Not that it means what she'll do, but what, you know, this is now going to fall on her instead of the DA.
Exactly. I think that's their MO, right?
The intense pressure that they felt just looking at the affidavit from the one juror in regard to the comment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that is exactly what the case law advises against and governs as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and
They called
indicate
the
to the
defense
court
within
exactly
48
what they
hours.
want.
They did because they want justice, because they are outraged.
The reason we're now weeks and months is because you're dragging it out with all this stuff. But they called the defense right away and said, this is a travesty. This is not what we did.
And they called Lally, and 3 of them emailed Lally. So Lally heard from 4 jurors directly, not through intermediaries or, interveners, directly.
Don't back up the timeline because it's been dragging out for scheduling in the court. They called the defense right away and said, that's wrong.
Right. And you know what? Today, I think it's Friday. Yeah. They could call the jurors in for Monday. Like, they don't need to keep dragging this out. They could tell them all, please come back Monday. We just want to talk to you, ask you a question under oath. That's it.
Going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that
It's not.
deliberative process.
No, it's not. No, it's not.
Any sort of
Deliberative process is we acquitted her because the ARCA guys were compelling witnesses, and this was lying, and this one didn't like this, and given the burden of proof, this is what we found. That's the deliberative process. The result is I found her not guilty, period.
Right.
Stop. That's not the deliberative.
Period, full stop. We need shirts, period, full stop.
I mean, this is intellectually dishonest argument.
Yeah. Yeah. Well, take it from where it comes.
When a contention or inquiry by counsel, by the court, at any point in time.
They volunteered.
When it comes to the adequate opportunity that counsel had to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for Arturo Rodriguez. And understanding that asking for Arturo Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process. And experience counsel.
He asked for it and he didn't get it. Right?
And equate asking for the whatever the Tui Rodriguez, Allen charge, whatever you want to call it. That does not equate to asking for a mistrial. To say that's the first step. No, give them the instruction. And you reboot the process. You have a right to change your mind anyway.
Right.
This is nonsense.
It's insane.
Counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their
They weren't done deliberating. Who cares?
Right.
He's too early in the process. It matters where were they at the end, and they're saying not guilty.
Yep.
Counsel, and these are Mr. Yannetti's own words, on both occasions, indicated that from them, or argued for Tui Rodriguez on both of those first 2 notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about is for mistrial at those particular points, or at least leading down. Now, as far, and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states. Counsel's request for Tui Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity to confer on possible alternatives to mistrial.
But that's before. They came back later. He's too early in the process. You're allowed to change your mind.
Right. Right. And so this is really just a non-issue.
Yeah.
He's throwing spaghetti at the wall. He's trying to confuse and conflate, and exactly what he did when he tried this case. Makes no sense to Michigas.
Herrera is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case and this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of
Careful, buddy. Where are you going here?
Argument against the court's decisions when it came to anything. There was even a perceived slight measure against the defendant's interest, and I would direct the court to the verdict slip argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that prototypical example of the manifest necessity is a deadlock or a hung jury, and that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Unetti during his arguments.
See, I don't mean to stop you, but I know the judge is listening today. This kind of oral argument is actually probably the type of oral argument where she ought to interject and ask questions. Because the money question for Lally is, what is the harm in bringing the jurors back and learning what happened? Can you direct my attention to what is the harm in that? Why shouldn't we do that? And let's figure out and go from there. And because his answer would be Hamada, 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 Hamada.
Yeah. Yeah. Right. What is he going to say? Because we don't want justice to be done, Your Honor. We really want to retry this case on all counts. We really want a different jury so we have a better shot.
This really would be more effective if this was done in like a classic appellate context where the judges would interject because, put him on the spot and like, instead of just letting him drone on with this nonsense, ask him what's the harm? I mean, don't you want to know?
Right. Don't we all want to know?
You can make your same arguments, but shouldn't we, Mr. Lally, find out what they meant before we get to these issues? And what's he going to say? We don't have to because we know, Your Honor.
Do you think she'll let Weinberg rebut? We'll see.
I don't know.
We know that we're way behind. We stop, we commentate. That's what we do.
She should. I mean, there's a lot of rebuttal here, on a few points, and I hope he would be given the opportunity. And I mean, she's not going to rule today. That would be insane because to me, the answer is obvious. You just get more evidence. That's what you do. I don't think you need any of this. Just get more evidence. Let's find out what happened.
Yeah, she could rule and say, okay, I want to call them back in. Let's call them in on Monday. That would be an easy out.
Very.
The dangers of coercion when it comes to deadlock jury are
coercion
stated throughout the case law, as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Luther decision from the United States Supreme Court to the Supreme Judicial Court of this Columbia, that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those, how the jury stands, or whether or not they have a vote, or whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when you're talking about charges with lesser included, or charges that have a multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty or guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe as far as not allowing the court to inquire into those types of scenarios. So I guess the defendant's position is that the court should have polled or inquired only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know if there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive holdings of the jury while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, and very deliberately, as far as the language that was used, declared themselves to be an impasse on 2 separate occasions, the last of which included language to the effect that any further deliberation is futile. That is the very definition of manifest necessity. And left this court with absolutely no alternative other than to declare mystery. And that is clear from the language of the jury's communications to the court, and it's clear from the case law and the rules and the law itself as far as what the court can do. The two areas that counsel is talking about and sort of asking for extension or creation of new law, again, sort of special or deferential treatment to this case or this defendant. The two areas in which the court can make post-trial inquiry have to do with some sort of bias, if there's an issue raised in regards to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance,
So the fact that she's a white woman with money means that, you know, she gets nothing. Like he's literally saying that, because the one that the jury was called back in was a case that I covered, and now I can't remember the woman's name who was murdered, but it was like 20 years later. It was insane.
I'm sorry, one
Oh, got lost.
What do you think Bev's thinking about? Put her thought bubble in the chat.
Her thought bubble is, I
in an
think
instance,
they're making me
which there
decide
is some sort of allegation or some
murder
sort of
charge.
evidence.
Idiots.
Say that again. Wait, repeat that.
I can't believe you idiots are pushing this narrative. The murder charge is weak. You should be doing this. You're putting this on me.
Yep.
She's not going to be happy.
Of extraneous influence. The defense not raising either of those issues. Specifically within those cases, what the court states, which is obviously binding on your own, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when they came to them expressing or wishing to have discussions about their deliberative process or their votes is specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror calls you, it still does not.
In sum, Your Honor, the defense lawyers are scumbags and unethical, but we're not. That's
right. Right. Look over there. Look over there.
Yeah. Yeah. This is rich.
With these jurors that delves into their deliberative processes or their deliberations. The specific type of coercion that is feared by the courts when it comes into this, and I'll sort of condense quote from Commonwealth versus Will. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlocked jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what is permitted. Certainly.
Is it prohibited by the interest of justice?
Well, you
and the
just
fact that there's no case law on point?
You just stole my thunder. The
I'm
law
sorry.
changes.
Take
No,
the
no,
thunder.
no. It's we're on the same plane here. The law changes all the time for the better, and new law gets made. Certainly, you have this concept of stare decisis. You go by precedent, and that's fine. But this is an unprecedented circumstance. These are jurors contacting the defense. We know what's going on. And here we go again. At the end of the day, it's form over substance. We don't care. We shouldn't want to know. And we just don't care whether they acquitted it or not. The law doesn't permit it. I mean, this guy is saying with a straight face, the law judge precludes you from even trying to find out as to whether you are going to be the first judge in the history of American jurisprudence to sit over an acquitted defendant for murder getting retried for murder.
Mm-hmm.
And if this judge has any sense of justice, she'll say, I'm not going to be the first judge who's going to preside over an acquitted defendant getting retried. And this is not making a good transcript, by the way, if she does deny it for an appeal. I mean, this
Mm-hmm.
is not an impressive argument at all that they're making.
And it's a double jeopardy issue. This is something that could go straight up to the Supreme Court. I mean, she said that she's expecting appeals on this no matter which way she rules. So this is a good case of you better want what you wish for, because she had multiple opportunities to get out of this case. Multiple.
And
She moved to civil court. It could have been reassigned to a criminal judge. She kept the case. She was asked to recuse herself. She decided not to. She kept the case. There were so many opportunities for her to walk away from this case. And now she got what she wished for.
The judgment of the DA, they will always tack to the wrong side from what they ought to do. All they had to do was say, we're going to dismiss the murder charge, take all this away. They look like the good guys. They look like they know how to use discretion. They use common sense. And now either way, they're screwed. Win or lose on this argument, they look terrible. People are going to think the conspiracy is deeper. The lack of justice is greater if they win. If they lose, they're going to say, look at you. Even this judge couldn't have this. This is horrible. All the jurors are watching, meaning the future jurors on a trial, saying you people just can't let go and do the right thing and use common sense. This is just another own goal. And the defense has already won whatever the ruling is here. This is awful.
Yeah, exactly. Let's move on because we're risking spoilers in the chat.
If I'm Baltimore, anyone wants to try someone who has been acquitted by a jury of their choice or retry them from the same case. That's not what's happening. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration.
This is where the judge should say, what's the harm?
Right, exactly. What's the harm?
If we're not in favor of trying somebody twice for the same crime for which they were already acquitted, but that's not what happened here. Yet all the jurors are saying that's exactly what happened. And he's focused on form over substance again. And the judge ought to say, what's the harm? Why are you so opposed to this? And he's missing the opportunity and letting him get away with this drivel.
She usually interrupts him. So this is shocking and shock and horror.
And finding manifest necessity as the only alternative that could have been employed in that particular case. Polling the jury then, polling the jury now. It's simply not permitted by the rules, it's not appropriate, and therefore the defense motion should be denied.
Can I reply, please? Thank you.
Marty. Oh, Marty, go.
We're going to be short and to the point. Watch this.
There are two cases that Mr. Lally relied on, and they both stand for very different propositions of law.
Bluford and juvenile.
Commonwealth versus a juvenile. It's actually juvenile versus Commonwealth.
He's going to do what we just said and blow him up.
1984. Says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, we deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. two separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts.
Nodding.
Commonwealth versus juvenile, was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser includers. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lally figured. That case.
She's nodding. She's read the case. She knows he's right. That's a tell.
Yep.
Created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser includers. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. And the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Buford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they were. They needed to decide all the different allegations within a single charge, and they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the jury coercion, saying, does your note reflect all charges?
What just happened? That's weird. They cut it off? Oh, man. Let me go back and see if I can find that on Court TV or somewhere else, because we got to watch the ending.
Yep.
Hold on, Graham had that. Oh, the sound is really terrible. Hold on.
Is that every stream they shut off?
I don't think so. Okay, wait. We'll get it back to him a little bit. All right, let's see. Got it. You might have to turn it up, you guys. This is like terrible. The other stream had the best sound, but they cut it off.
For a TUI instruction, you are really asking for something more than a TUI instruction. TUI means I want this jury to reach.
Exactly.
And that's what Mr. Yannetti was saying during those 2 colloquies.
Making all the perfect rebuttal points that we're talking about, just hitting on. It's great.
We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a here that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not? And if it's so,
Compliments will get you everywhere, dude. Hold on, we gotta hear that again. He just totally I wish they would focus on her because I wanna see her blush and twirl her glasses around.
System than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence, a second 12, when she's already convinced the first 12. Thank you, Judge.
Perfect rebuttal. That's exactly what rebuttal should be. Short, to the point, boom.
All right, thank you very much. I'll take this under advisement.
All right. Thank you very much. I'll take this under advisement.
Sure, thank you.
That's it?
That's it.
Oops.
That was a good day for defense. Like that.
I'll just mute this so we can at least watch what happens. Tell us what say you, Mark.
That was a clinic by Mr. Weinberg. That's exactly how you make argument. He had the right demeanor. He had the right tone. He had the right substance. He tried to give the chance the DA to join the good guys and be the truth seekers that they're supposed to be, knowing full well they wouldn't. He hit all the points and made it clear. You're talking about a fundamental constitutional right with evidence that she may very well have been acquitted. Why wouldn't we want to know? And he did everything that, we've talked about for weeks and months. He focused on the substance over form, the significance of a key constitutional right, avoiding a possible retrial on something that had been acquitted. And I think his ask was appropriate. I'm so glad he did it this way. Just give us a hearing. Let's take the evidence and go from there. And the DA did everything that we've criticized them for in the past. They focus on form over substance. They meander and drone on. They pretend to give lip service that nobody wants an acquitted defendant to be retried twice, but that didn't happen here. That didn't happen. Even though all of the evidence that was submitted to the DA, as well as the defense to the DA, is that that's exactly what happened. And you may disagree with it, but to say that there's no evidence of that because they didn't publish the verdict by checking off a box, and then you cite cases, which I'm so glad on rebuttal, as we were kind of muttering under our breath that were not on point, right up and explained why they weren't on point. So they won. I think they have a legitimate shot at getting the hearing, but even if they don't, they're going to win the battle of public opinion on this. I mean, who looked like the good guys today, and who looked like the people trying to obstruct justice and obstruct the judge from knowing what really happened? And the guy in the white hat today was the defense. And the DA looked like the obstructionist, and that should never happen. But it happens all the time with this office in this case. It just happens again and again. Really shouldn't be surprising at this point. And whether they win or lose, they've made their point. You know how this is going to get reported. Do you want, she has to convince 24 jurors to find her not guilty?
Right.
I mean, that's a great finish. And that's why they're, look at them, look at their body language. They know.
Yep, they're happy.
These are smart people because they won. And they may very well win on the law, but even if they don't, how can the DA try her for murder after this? How can they do it? How can you pick 12 new jurors on a murder case knowing what's going on?
Why are we still here? I mean, why are we even still here at all?
All they had to do was just say, Judge, we're going to treat this as a manslaughter case. And none of this happens. And then they get the good press from all the reporters instead of the atrocious press that they're going to get, and how this is going to go on. And now they're putting it on the judge. And suppose the judge rules in favor of the defense, which I'm not predicting she will or she won't. But how bad is that going to make the DA look when everybody thinks, oh, she's in the tank? don't underestimate the fact that just because she's been hostile to the lawyers, doesn't have any particular affinity for Karen Reed personally, just don't assume that means that any judge, including one who used to be a legal aid lawyer for what it's worth, means in their mind that they're thinking, you know what? I want her to have to get tried twice for a crime that she probably got acquitted on. I mean, that's a tough sell that she's going to want to do that. And if she denies it based on the argument that's been had without any evidence from the jurors beyond the affidavits that were submitted, then she's going to get heavily criticized. She may very well get reversed. And I think, as Weinberg said beautifully, there's no precedent for this. So the case law that the prosecution is trying to use to block this is not on point at all.
Right.
And as Weinberg did brilliantly, in situations that involve, if you had a jury that was not fair and impartial, of course you'd bring them back. If you had a situation where a juror allegedly was subjected to outside media, of course you'd say you bring them back. But if there's strong evidence that they acquitted the defendant, you're not going to even attempt to equate that as the same level of due process and double jeopardy in this situation to bring them back about a fair and impartial jury and not getting tried twice. That makes no sense as a matter of just simple justice. Again, you have to pick a side, form or substance. And in this case, the DA has gone with form, and that's horrible.
It's a bad look. It's a bad look for Massachusetts. It's a bad look for Norfolk County. I thought his strategy of flattering the judge was brilliant. You catch more flies with honey. Will she eat it up? We don't know.
I mean, the dichotomy between the two presentations today, and you would think that the defense were the guys in the white hat, that they were the ones talking about what a prosecutor's role is. And you'd think that the prosecutors were the, stereotypical, well, the defense is always trying to, obfuscate and do this and confuse. And that's what Lally was doing. Okay. And for him to wrap himself up and saying we were ethically precluded from even exploring this. Well, let's explore it now.
Right.
Let's explore it now. Or when you got the calls from the jurors, why didn't you call the court and say, Judge, we need to talk to the jurors. If you think you ethically can't do it, then we need permission to do it. They are not interested in the truth. There is nothing to suggest, based on what you saw today, that the DA's office wants anything to do with this other than having it swept under the rug and just saying that, there was no verdict and we don't want to look into this. And I think it couldn't have been any more obvious. And somebody's talking about the flying monkeys. It is like the Wizard of Oz. Never mind the man behind the curtain.
Right.
Weinberg kind of looks like the guy from the Wizard of Oz, by the way. Not that he's the man behind the curtain, because he's the real deal. It's not smoke and mirrors, it's real. But the DA is basically saying, let's just pretend none of this ever happened. Forget the jurors. They're too dumb. They're going to be offended. Okay. I mean, imagine if you're one of these jurors who acquitted her, and the DA is saying, we're not even interested in having this explained to us, and they retry her for murder. Imagine the conscience of those jurors who sat on the first case that said the judge, the DA, nobody even wanted to hear us explain why you shouldn't be able to do that.
Exactly. Tui, thanks for the 5 predictions. Anyone coming for Officer John O'Keefe's actual killers?
Well, who? I mean, the Norfolk DA it's Karen Reed or bust, clearly. And even if they wanted to, the crime scene is destroyed. The evidence is terrible. I mean, no.
That's not what the FBI does. That's not what they're doing, right?
No, they don't. I mean, they do corruption and other things, and their jurisdiction over murder is very unique. And even if they built some grand conspiracy and some RICO conspiracy, which they're not going to, maybe they could argue that the cover up or the murder of John O'Keefe was part of, an overt act in furtherance of a conspiracy, but they wouldn't be charging her with or charging someone else with an actual state crime murder.
Yeah, and the evidence, where there's no evidence. Dee, thanks for the 20. And Dee was right. Bev had these motions for weeks. She knows what's coming. She had plenty of time to confer with her judge group for guidance with a ruling. We will likely not see her ruled from the bench, which seems irresponsible and weak. Agreed. And how long is it going to take her to rule on this?
I don't agree, actually.
You don't
Uh,
agree?
no, you need to publish a written decision on this, and
Mhm.
it needs to be solid, and it needs to deal with the case law, deal with the filings. And I think if you're going in a way where there is no case law, state your reasoning. I think the whole credibility of this entire court in Norfolk County is at stake here. And this is, to me, one, you don't rule from the bench. You spend a lot of time and write a very detailed opinion for another reason as well. Somebody's going to appeal this. And if everybody knows there's going to be an appeal, you need a written decision to appeal so that you can present it to an appellate court and really break down her reasoning. And I think even her acknowledging that I know either one of you is going to appeal, that really obligates her to put this in writing, explain her reasoning and thought process to give each side a fair shot in an appellate court. So I think.
No, well, I meant I agreed with her because she said we will not see her rule from the bench.
Oh, right.
And
Yeah,
that's
no.
what the comment said. And also she said a lot of time to think about this and talk to her judicial
Oh,
friends, and that she's probably already got her mind made up. But yeah, it's got to be written because you need to appeal it.
right.
Right. So yeah, and that's
Yeah, I misunderstood with the comment. I thought she was saying she should have ruled right away.
Oh no, I think she said we will likely not see her rule from the bench, which yeah, I think you're right, but I think it does have to be a decision because this is a decision that's lawmaking, that is case making, you know?
Well, this has
That is
precedential value too, because
That's what
this,
I meant to say.
yeah,
But you said it more eloquently than I did.
this is not covered by these cases that they're all citing. I mean, this is virtually unprecedented. And notwithstanding Lally's claim that this just can be pigeonholed under the precedent that says, getting into the jury's deliberative process is a no-no. I get it. Nobody wants to bring a jury back and say, explain yourself. That's bad. You can't. No juror should ever have to literally justify their reasoning. But that's not what this is. This is very simple. Did you acquit or not? And if you did, then tell us why you didn't check the box off and what happened here. That's not explaining why I found her not guilty or why I didn't. And when he keeps saying you're getting into the deliberative process and ethically I'm not allowed to do this, which is also taking a dig at the defense for taking the different interpretation, this is like gobbledygook. I don't know what he's talking about. It's, again, intellectually dishonest, I think.
And not very stimulating. Massachusetts changed the jury instructions approximately 10 days after Karen's mistrial, says Glamasuz. I don't know about anything about that. Do you?
I heard something about it, but I don't know that it relates to this per se. I mean, or about anything about, we need to know what your verdict is or non-verdict in terms of being clear. I'm not sure it has anything to do with this.
Yeah. Blessed in Texas, thanks to 20. Lally's a subpar ADA who lacks professionalism. He lies, and it's so obvious, and gets away with misleading jury and judge. How? Who oversees this behavior? Who disciplines? I'm amazed at how much ADA gets away with. Sigh.
Well, he fails a lot of the tests of being an effective litigator, and I think today would have been the day to make eye contact with the judge and do what Weinberg did. I'm speaking passionately, yet calmly, because we're talking about a fundamental constitutional right and potentially retrying an acquitted defendant, which is as un-American as it gets. And all Lally does is stare at his notes, drone on, and he mentions in passing, nobody wants her to be tried twice, but there's no evidence of that here. There's no sincere addressing the real issue here, which is there is evidence. You may not think it warrants a review, but you're not telling the truth when you say there's no evidence that they reached a verdict. There's affidavits up the wazoo saying the exact opposite of that. In fact, you submitted a written document which you felt obligated to disclose to the court and defense because you had conversations with someone who told you the same thing. And that was so unimpressive the way they handled that. But none of us should be surprised at this point, but
Yeah, I mean, we're surprised that we're still here, and yet we're still here. Thanks, Glitter Beauties. Question: Can the defense file any motions to look into fanning and jury tampering? How they got rid of the 3 very pro-Karen jurors, didn't pick from seat numbers, but the original numbers, etc. That was one question, and then there's another question here with regard to fanning, that said, "Can you please explain what's going on with Fanning?" So apparently, have you heard this, that Fanning was in charge of the jury? Like, is that
I'm certainly familiar with what came out and what was reported and said. I would say it's too early to assume anything. It's not so easy to work backwards and say, well, did he play a role in getting jurors turned into alternates and all of that? You need evidence. What now? Again, that if that takes the form of an affidavit of a juror or somebody saying this is what happened, well, at that point, maybe you have something. But the defense is not going to throw a motion on the court and say that we read an article that it appears that the jurors who were pro Karen Reed jurors were not picked as jurors. I mean, that's a bridge too far. What's fascinating about this is apparently the jury members at issue are the ones from the day that we went when that whole
Yes.
to-do was going on, and they were the ones who clearly were being called up to contradict the one juror who was dismissed.
Mhm.
And it's been reported by others, this is not us talking, but it was reported by others that she had a problem with Karen Reed looking at her family and whatnot, and other jurors reported that. And then all of those jurors who the argument is are apparently pro Karen Reed, which I don't know how you define that, by the way. But they're the ones who all got taken out of the pool and became the alternates. Now, that is concerning in the sense of, I'm not a statistics expert, but that seems statistically hard to believe.
Mhm.
How did that happen, or why did that happen? I don't know. If there is an allegation that Fanning somehow was advising the court that something was wrong with the juror, well, that's troubling, because I'm not sure why it would be the role of a state trooper to do that, particularly one who was on the witness list,
Right.
worked in that homicide unit with his subordinates, Tully, Proctor,
He was on
Buchanan,
the group text messages
on the
with
group text.
Proctor.
So that man had no business being within 100 yards of anyone in the courtroom. Now, I don't know if he was or he wasn't. I have no idea.
That's my question. Like, if they put this guy in charge of the jury, that's a huge problem. He's a witness in the case.
Problem. And then, of course, the next question becomes, what does that even mean? I mean, he's not a court officer. So the court officers are the ones who run the
Mhm.
security. However, there's another angle to this, which is, in this particular case, there was so much publicity and they had multiple law enforcement agencies helping with security and doing things, maybe escorting jurors, and was Fanning part of that? If he was, that's a no-no. The guy is tangentially or not involved in the case, on the witness list, and directly related to the other state police witnesses from the Norfolk homicide unit. He shouldn't be doing that, and that would be really disturbing. Somebody also said that he did the background checks, which is, again, that's inappropriate. He shouldn't be doing that either. He's involved in the case. Now, does
Right.
that mean that he told people who shouldn't know things? No, it doesn't. I mean, you still need evidence of that. So to get to the point 15 minutes later, I don't think these defense lawyers are going to be filing a motion literally based upon a report that came out. What they'll be doing is trying to investigate it. And if it bears any,
Right.
then yeah, you file a motion. But they're not going to file a motion because a journalist wrote a story saying, I've learned this, because you still need the connection.
Right, but it could be that they're holding it in their back pocket for the
I,
next motion. Like, they're
I,
definitely, I'm sure they're definitely looking into it without
you
question.
have, oh God, yes. I
When you
mean,
call the jurors in, you can show them Fanning's picture and be like the judge knows if Fanning was, because I've heard that it is the troopers that have something to do with the jury in this courthouse. And like, how do they pick him when he's on the witness list? They have nobody else.
I mean, look, I know the state police is a big agency and they're the law enforcement, they have a law enforcement side and, other things, who they may not be part of the law enforcement. So I can understand maybe allowing other parts of that agency doing some kind of quasi security function, but not the supervisor from the Norfolk County DA's office homicide group that lives in that DA's office and where he hangs out and yucks it up with Proctor, Buchanan, Tully, and you could go on with the other guys.
Looking for nudes that he's gonna distribute in, presumably to Fanning from the whack job's phone. Like,
I mean, look, you want to talk about conflicts of interest? That's the worst kind of conflict of interest, but that's part of the entire problem with this unit in the state police office. I mean, another example, and I want to not get into the details of the other related case that is not the Karen Reed case, but in that other case, the DA's office felt compelled, properly so, to say we're out. Okay.
Mm-hmm.
But the state police didn't. Okay. The state police are investigating that case in which two of the so-called victims in the case are state police troopers.
Oh.
And they're investigating it, including
That's interesting.
one of the so-called victims in that case has been investigating the case in which he's a victim. So once again, there is a larger problem with the Norfolk County DA's office and their relationship with the state troopers who were encamped in that office. It goes deeper than that. They donate to Morrissey.
Mm-hmm.
I mean, somebody posted this online. Some of these people in the state police, including the prosecutors themselves, donate to Morrissey. And that makes you wonder, why is that?
Right.
That happens nowhere else. That breeds corruption, or certainly an appearance of corruption. It breeds favoritism, that there's some kind of, you're obligated now to help me and I'll help you, or this or that. And it goes back to, this whole office. Whenever they're supposed to look left, they go right.
Mm-hmm.
If common sense says go right, they go left. They have the worst instinct and self-awareness of what a law enforcement agency is supposed to do. And it's no wonder why half the people in that county and around the country, if you play word association and somebody says Norfolk DA and they spit out corrupt,
Right.
That's why, whether it's fair or unfair, it's not unreasonable for people to think that, given the way they do things. And if the supervisor from the state police homicide office is somehow mixed up with the jurors in any way, it's another own goal. Why would you do that? Is there nobody else?
That's what I'm saying.
Seriously. No
They
one
don't got
else.
another guy. They don't got another guy.
You don't got another guy.
You don't got another guy.
We'll have to see what happens. But you can be sure that the defense, and they certainly have a lot of time to do this, they'll look into it and we'll see where it goes. But it also, we'll see what happens. I mean, is that why Fanning was under investigation? Now, he got kind of cleared. He got cleared.
He did. They dropped it,
Well,
but
he got the nose holding cleared. He got the unsubstantiated, not exonerated. There's a difference. Not legally. I mean, he's in the clear, and fair enough. I don't know what he did or didn't do. I have no opinion. I don't know anything about him other than what I read and study on other things.
Could he have made a deal to cooperate with the other two's internal investigations in order for his to be dropped? Is that a possibility?
Well, they dropped it though with like an unsubstantiated, which is like, we can't really prove or disprove, which is like, there's just no evidence to either way.
Mm-hmm.
So I doubt it, but that's certainly different than the other three, right? Who are still in the soup, one of whom is hanging by his
Yuri and Buchanan. I mean, so Yuri and Tully and I guess Proctor is still pending.
Proctor's formality. I mean, obviously Proctor's toast. And we go back to the letter that we talked about earlier. Yeah, he has literally no use to the state police at this point.
Mm-hmm.
All he is essentially, the DA hopes is that he's not like a metastasizing cancer that hurts the rest of everything else they're doing. I mean, he's poison literally to them, and they hope they can just get rid of him and he doesn't destroy these other horrible murder cases. But the other guys, I don't know. We don't even know if they're under investigation because of what happened in this case with the text messages that they liked or knew about, or whether it goes any deeper. So, I was on a streaming show the other night with a very distinguished ex-Massachusetts state trooper who people have seen
Mm.
making rounds. Really good guy. And he thinks this case is a mess. And he was a state trooper for, 20 years or so. And I asked him in his experience if he thought that the internal affairs for the other guys was related to just the text messages or not. And, he kind of thought, it sounds a little more serious than that.
Yeah, what show was that if people wanna go check it out? Thanks, Sharon.
That was with the Young Jerks the
Oh,
other night,
okay.
and that was which will be on at 7 o'clock tonight, by the way.
Alright, cool.
That was with Todd McGee, if anyone knows who he is.
I do, I've
Really,
seen him
re
on
yeah, really
New
impressive.
maybe?
Um, he's everything that, people who say I'm so upset about corrupt cops or what they perceive to be corrupt cops. If you want to restore your faith in humanity and what a good police officer is,
Right.
then go look at Todd, because that was him. They're not all bad. Most of them are not. The problem is nobody has any confidence in what's going on in this particular unit stationed in this particular DA's office. And here we are a month after the trial, and 3 of them are in trouble. And
Right.
if you said, which is more likely at this point, option A is that Karen Reed goes to jail or prison for anything, or B, Michael Proctor or somebody else from the state police goes to jail or prison for something. I'm going with option B is more likely.
Mhm.
And I don't
Yeah.
even know how likely that is. I don't know if he's ever going to get charged or get in trouble. I have no idea, but I feel like there's more there than there is with Karen Reed for sure.
Yeah. Illegally read, did a juror admit to being intimidated by Brian Albert? Yep. They
Uh,
misspoke and said Higgins in
yeah,
the
clearly they meant Brian Albert. And that was in one of the affidavits. In all fairness, just to be fair to the process, there's nothing improper per se if Brian Albert sits, in a courtroom and is just looking ahead. Now, whether he's trying to intimidate, whether it has that effect, who's to say? Certainly, the juror felt
Mhm.
it,
He felt
but
intimidated, the juror he or she did, yeah.
the mere presence of him sitting there, it's not illegal in any way.
Yeah. I
And
don't
he's
think any of the jurors were present in the court, Ashley wants to know. I don't think any of them were there, but I don't know for sure.
I
They weren't
doubt it,
asked to be there. Why does he keep using the word coercion?
because they have the worst instincts and the worst judgment and just not smart argument. The jurors are not coerced. They contacted the defense.
Right.
Okay. They started this process. The only reason this argument occurred today is because jurors, at least 4, possibly 5, on their own, separate and apart from each other, went out of their way to say, we're going to call the defense. At least 4 of them, whether they're the same ones or different, went out of their way and said, we'll even call the DA, who, of course, doesn't want to talk to you. So why, with that fact pattern, would you say the concern here is that the jurors are being coerced or could be subject to coercion? They literally started this process. Literally.
Voluntarily. Yeah. And it's interesting that Mr. Weinberg brought up Murdoch, because in Murdoch, the attorneys actually went and started knocking on the jurors' doors to find out if there was any jury tampering by the Becky Hill, the clerk of court down there in the low country of South Carolina. But
Right.
again, the rules permit that in South Carolina, where they don't permit that here
And
in
they do it in New
Massachusetts.
York. It happens all the time.
Mhm.
But that's the key, is there's no precedent for this. So when Lally is citing all of these cases that are founded on the premise that, the defense is banging on the doors of jurors and trying to drag them in, it's not surprising that some of the dicta in the court opinions would say we're concerned about coercing jurors and making them nervous and having them explain what was going on. That's not what happened here. They read news where they heard that there were, hung juries on all these counts, and half the jury is looking around saying, that's not what happened. We acquitted her on these counts. And they contacted the defense. Some of them contacted the prosecution. So they're clearly at least willing to address this and, go out of your way make sure they remain anonymous. We know the one juror submitted that, let's call it what it is, bizarre motion about, I'm nervous and I thought I was
Right.
followed. And then I read all this social media, but then they were citing social media from,
People who are dead.
well,
Yeah.
people who were dead that would have been buried. You had to dig deep, in other words, and skip over a lot of other stuff. Using non-original source articles from, let's be honest, people with a big agenda, one way or the other on the case. It wasn't even, most lawyers would use in submitting that paperwork original source data, but
Right.
so whatever that juror did, it is what it is. I don't really have an opinion on it other than it was a weird filing. But all the defense did here was say, why not hear from the jurors? Why
Mhm.
anyone with a
Right.
sense of justice? And he totally disarmed them, gave the DA a chance, as I said, hold their hand, come with me, let's walk in the light together. And that's when the DA should have turned left. And what do? They go to the right. They just can't do the right thing. All they had to do was
Mhm.
either be sent to a hearing or dismiss the murder charge, and they would look like well-disciplined, well thought out professionals. And they
With
did the
integrity.
That's
An
right.
office with integrity. But
And
I
they
think that they would get too much pushback from, not only the O'Keefe family, but all those other people who testified as witnesses on behalf of the Commonwealth.
the
And
role, I got to tell you though, and you know this, obviously, the
Mhm.
role of the prosecutor is to do justice, do what's right, do what's wrong. And you see this all the time. You're always going to be concerned about what the family of a victim is going to do or say, but you can never let them dictate what
Mhm.
your ethical, moral, and legal responsibilities are. You can be concerned about their feelings, obviously. You can want to hope that what you do aligns with what they want, but you don't make decisions about a woman's right to due process because a family thinks, I don't care what you say or what the jury said, we think she murdered him, is not a reason to try someone for murder unless
Well,
there's
you're not
credible
supposed to.
evidence. And I mean, you would think that if nothing else, the DA would say, well, clearly the murder case is weak, just based on,
Mhm.
they're not disputing, by the way, the affidavits, as you said earlier, where they previously said this is unfounded, this is ridiculous. They were very dismissive of double
Mhm.
hearsay in this. Well, they have to walk away from that. Now they're just saying, well, they didn't check a box off, so who cares? But if you put all that aside, do they not draw anything from this, such as, I don't know, maybe, playing all those text messages and voicemails and witnesses from Aruba and all that other stuff, and taking on a burden that's just too strong, that maybe that's not the right way to go?
Mhm.
Apparently not.
You would
Apparently
think.
they have learned nothing from this process, which is why some call them zombies. They just keep coming. Like, it doesn't matter
Some
what
call us zombies too, Mark, in all
well, that
fairness.
that's
Come
true.
grift with me. Come
I
grift with me, Mark.
I any chance to grift, I can't resist. Um, Whatever that means in this context, that those people still don't know what it means.
I know.
But the DA, like, they take no lesson from anything. I mean, it's not a murder case. It never was a murder
Yeah.
case. I don't think it's anything, but certainly not a murder case. I mean, isn't
John
it
O'Keefe
just,
wasn't hit by a car. He just wasn't hit by a car. I'm gonna say it louder for those people in the back. He was not hit by a car.
I mean,
That's how easy it is.
all those
Simple.
people in the house, none of them heard her slam it in reverse and smash into him right in front of them, 10 feet away, 20 feet away. It's quiet outside. There's
Mhm.
no one on the street. It's starting to snow. It's 12:30 in the morning. Well, they didn't hear anything because they were watching It's Raining Men. Is that, I mean, this is
Let's address this because she's asked it twice, and justice for all. Wondering why the judge was so quiet today. Do you think she was told by her superiors to be quiet and just listen? Do you think she was told by her superiors to be quiet and just listen? And then she also said, I did find it interesting the judge did not say a word during the attorney's pleadings. I'm wondering if she was told by superiors to be quiet and just listen.
no, I think she was captivated by what was happening. And if nothing else, she realizes there's a lot going on here. And I think she was, in some sense, persuaded by what Weinberg was saying. I don't know what she's going to do or not do. On the other hand, she may have been listening because maybe, if you take the opposite approach, if she's not up to the legal issues at the moment and not well versed in it, then the best thing you can do is sit there quietly and say nothing, right? So that everyone doesn't know that.
Mm-hmm.
I think it would have been helpful if she was more involved. I don't mean cutting them off in the way that happened at the trial, but to ask again in the context of like appellate argument, very focused, relevant questions to some of them and see what they said. And I think the biggest missed opportunity was to say to Lally, what's the harm?
Mm-hmm.
If we all agree nobody should be tried twice if they're acquitted the first time, and we all agree that there are multiple affidavits saying that's exactly what happened, why not ask Lally, well, do you object that if I brought the jurors in and asked them, can you explain not the deliberations, but explain the failure to publish the verdict?
Mm-hmm.
What is the harm in getting that answer?
I
And
know
what
why she didn't do that, because she's playing mommy and she knows that she does not want to put her little boy Lally on the spot because she knows he's not going to know how to answer the question properly and it's going to make him look like a fool. And that's my opinion and I'm sticking to it.
that's
It's like,
okay.
Mr. Lally, do you want to object? Do you want to object, Mr. Lally?
I,
That would have been the right thing to do
yeah,
and it
and
should have been done.
it should have been done, and make him answer the difficult questions, because if he's telling you none of us want her to be tried twice if she shouldn't be, then how do you explain this? And I think, again, how well versed in the law was she? I don't know. But what would have happened in an appellate argument? I mean, look, if you've ever, I mean, I don't know who argues in the appellate division or the Court of Appeals, but this is what happens.
Yeah.
If this was in the appellate division,
Pressure.
yeah, I mean, if this was, we're getting all hyper local for us, but like in the
Yeah.
first department, the minute Lally starts with Bluford and Juvenile A, you and I both know what would have happened. One
Mhm.
of the judges up there would have said, excuse me. But in that case, didn't the jury go back and deliberate further? And isn't that why the Supreme Court said this? And he would have to say yes. And then the judge would follow that up and say, well, then why does that cover here where the deliberations were over? Isn't that different? And it would be Hamada, Hamada, Hamada.
Mhm.
And with Juvenile A, or whatever the name of that juvenile case was, same thing with the slips on the floor that were found saying not guilty. Nobody knows when those were made. Those could have been thrown on the floor because we agreed to revisit it or rip them up, throw them on the floor. That's totally different.
Yeah, or somebody could have picked them up after the fact, like the cleaning person or the janitor, and just checked the box and threw them back in there. Like,
So
you don't know.
And also, who knows why she didn't do it. But if she did act more in an appellate posture today than just, I'm going to hear argument, that would have also obviously favored, Weinberg 1,000 times more than he already
Yeah.
dominated. I mean, in terms of lawyers who just keep score about who's better and who won just in that petty lawyer way, obviously this was a first round knockout by Weinberg.
He's been practicing for 52 years, which goes to St. Elmo's Fire's question here. Do judges allow deference for older attorneys whose lifetime of work speaks for itself? Well respected.
Yes, I wouldn't phrase it that way.
Right.
He's a well-known, highly respected, brilliant appellate lawyer. So yes, is his reputation going to precede him? Absolutely. Is he going to get deference from a judge? Yes. But the real reason why he gets deference is because he's brilliant at what he's saying. He's making perfect sense. His arguments are good, and he captivated the audience, which in this case was one judge. So that's the real reason why he gets the deference, because he's good.
Masterclass in oral argument, by the way. Amy's Positive Pathways. So how do we learn Judge Bev's decision? She will publish it.
Publish it. Yeah. And I think it'll be a while.
How long do you think? Yeah. That's what I'm wondering. How long do we have to wait?
Well, putting all the jokes
It
aside.
won't be Monday. It won't be Monday.
And, people make jokes about her, which, they're always talking about, the sidebar and the cottage and the cape. I don't like to get into that stuff, but it is summer. She does have till January in terms of the retrial, although you'd have to account for the appellate time. I don't think you want this to linger too far, but this is not an easy opinion to write. I mean, put it this way. If you're denying this, right? Suppose her position is, I'm going to deny this. you're going to get criticized. So you better explain your reasoning
Mhm.
and account for the fact that these jurors all said that she was acquitted. If you're granting it, okay, you're going to have to really distinguish all the case law and everything else that Lally was saying and say why it doesn't apply and why I'm essentially creating precedent. So this is not an easy opinion to write either way because there's no precedent for this.
Let's hope she has a good law clerk because that's who usually writes the decisions anyway, at least in New York, right?
Yeah.
Mama Smith says, "Do you think Lally would really appeal if Karen wins?" And then Leanne says, "Can this all be dropped?" I mean,
So I wouldn't appeal if I were them
yeah,
because,
Lally shouldn't appeal.
but which means if I say I wouldn't, means they will.
Yeah,
Uh,
they'll do the opposite of what we think should happen.
it's just historical precedent. I mean, I would think, but again, the mistake they will have made in that situation is letting it get this far because that will be humiliating if Judge Canoni denies them and basically says, I'm not allowing a retrial for murder over the objection of the, basically over the objection of the prosecution. They look foolish. But again, I don't think the decision here is going to be an all or nothing. I believe her decision is going to be we need more evidence. So I think everybody should expect slow your roll a little bit. There's a lot more process to go on here. She's not going to dismiss the murder counts or the other count 3.
Mhm.
What she's going to say is we need to go to the next level, which is bring me the jury.
Yeah, and then Sharon says, "How long does it usually take?" With her, I mean, there were pretrial motions that took 7, 8, 9 months for discovery,
This
for her to decide on, but she can't take that long because she's
no,
got a trial date set for January.
no,
Um,
and if you're just bringing in the jurors anyway,
mhm.
that's a much easier opinion. In
Yes, and
other
she doesn't
words,
call the attorneys back to render the decision. She renders it on paper. It gets filed in the court file. They're served with the order, but usually they're watching the docket and they'll see when it's filed. So that's how
of
that
course,
happens. They don't
yeah.
call them
So
back.
the way this case works, someone online will know before the lawyers because there are people
Exactly.
like,
You and I will have a copy in our
right.
inbox
I
before
mean,
David Yannetti and Marty Weinberg and Alan Jackson do.
there's probably 50 people online who just like refresh, the docket 24 hours a day. So they'll
Yeah.
probably know before the lawyers.
Yeah, I don't think a lot of judges do not like to be overturned on appeal. So this is a good question, Justice for All again.
Uh,
So, especially, I don't think that she would like to be overturned on appeal.
How would you like to be reversed by an appellate court saying, yeah, we're not going to allow a woman who may have been acquitted of murder be tried again for murder? Again, do you want to be the first judge in American history who makes that mistake? The answer is going to be no.
Mhm.
I look, there's a lot of controversy about her, and people attack me all the time saying, I mean, I think she made some bad rulings the first time around. I think she was not sympathetic to the defense. I think, she wasn't necessarily a good draw for the defense, but that doesn't translate to corrupt.
Right.
Okay. It doesn't.
Right. It doesn't. I
And I
mean,
think she's corrupt. I just think she's like a lot of judges. I mean, she's not that unique in my experience about
right. We've
being
seen worse, right? We've seen
I've seen
worse.
much worse. And I also think that the idea that she's going to want Karen Reed to be retried for murder if she was acquitted for murder, just because why I don't like her, because I
Right.
barked at her and I don't like Alan Jackson. So I'm going
She
to show
laughed
that I'm going to let her get tried for murder again.
because she didn't take her shoes off, Mark, when
Right.
she went in the house those 2 times.
I'm not buying that the judge is literally going to do that. And if she did do that, that would be by definition a grotesquely corrupt act, obviously, to have your judgment influenced out of personal bias and animus against
Mhm.
the defendant. I don't think that's going to be why she does that. And I think either way, whether it's legally or practically, you can see why the wheels are coming off this case. And she's not getting retried for murder.
Wheels on the bus go round and round. Yeah, Julio Suave said, "I now think he said August 8th on purpose." I don't know what that means.
I don't either.
He did say it's today, August 8th. But,
I don't know. Today's the
yeah,
9th, so I just think he made a
y
mistake. I don't
I think so too, because most of us typically don't know what day it is. I have to constantly look in the right-hand corner of my computer to tell us what day it is. I disagree with you because this is LT33. Thank you for this 10. if she does go back to trial, they will absolutely keep murder on the table. They know they won't get a conviction on it, but they will hope the jury splits the baby and convicts on manslaughter. I don't see, after everything I've watched them do pre-trial, during trial, and post-trial, I just don't see the Commonwealth just by themselves agreeing to withdraw that count
Well,
without a court decision. I don't know. That's my gut. And I know
well,
so we disagree on this, so we'll see who's
yeah,
right.
of course. No, that's fine.
Yeah.
I don't think they're going to retry her at all. Not because they want.
Really?
Yeah, I don't know how they're going to do it. I mean, let's start with this. First of
I'll
all,
full screen you for a minute.
on the
Oops.
murder, I mean, just the murder charge, everyone's going to know she got acquitted. So if you try her for murder, they're going to look ridiculous. But the whole case, you look at the mechanics of the case. Proctor, Buchanan, Tully, you can't just wipe them out because without Proctor and Buchanan, who's going to say I found all the taillight pieces, that ridiculously showed up after 3 weeks? That you don't have that. These are the people who interviewed all the witnesses. What if you don't have that? These are the people who vouchered all of the evidence. What if you don't have that? Or do you have it and they're just going to get killed on cross and it's going to be worse than the first time? Um, are they going to call Trooper Paul again? No, I think we all agree he's gone. But what if they don't find a credible expert to challenge the ARCA people? How are they going to go forward? I mean, you can't go forward unless you get a real expert. You can't go forward unless you're satisfied that the state police that are in trouble are going to be okay. And I'm okay with this nonsense about the taillight and all the other stuff. The defense is going to be better the second time around because they have the benefit of experience and transcripts. Not that they were bad the first time. They're not. These are some of the best lawyers you're ever going to see, ever try.
Mhm.
But they're going to be that much better the second time around. The feds are probably going to give them more materials this time around. They're going to prepare with the ARCA witnesses like they didn't the first time. What is the DA going to do? The
Yeah, it's
defense.
so interesting because and you say this a lot, and I say it too, is that their case is only getting worse because all their witnesses are dropping out. They're going to have nobody left. I watch sometimes to see what they're talking about on these other programs, and talking heads are like, no, no, the prosecution's case gets better now because they've already done it once, and it just makes no sense to me. It defies logic.
Are these lawyers?
Yeah, like on the mainstream media, like the News Nation, the Court TV.
I
I don't
can't
see it.
tell anyone listening or whether you're a lawyer or not, there is no chance whatsoever that a retrial will favor the Norfolk County DA in this case, unless they go to the witness store and buy a witness who says, a credible witness who preferably,
The
is
witness store.
a priest and, all of that, who says, I saw Karen Reed run him down. And then she told me in confession, putting aside privilege issues, that she did that. And I'm not
Mhm.
talking about McCabe style, I hit him, not that nonsense.
Right.
So all of these witnesses now have transcripts that the defense has. They're going to find every inconsistency. Is Brian Higgins going to testify again? He's in trouble.
Yeah. Yeah.
I don't know if he's getting indicted federally, but his testimony has problems. Okay. The inverted video. How are they going to fix that?
It was
Which
intentional. Thank you,
begs,
thinking for myself for your super secret.
but that begs another question.
Right.
Forget Proctor. If you're Buchanan, are you testifying about that again? I mean, don't forget his direct examination was as he's leaning on the chair, like, very confident that, yeah, that's a fair video and that's me and that's Trooper Proctor and that's this. And only on cross, oh, oops, it's actually, it is inverted and I don't know who that person is. I'm not sure who that is.
Mhm. And since then, what have we seen? We've seen him knocking on doors of women, questioning them about whether they sent Facebook messages or text messages to Lizzie Proctor and Jen McCabe. Like, now there's like, not that judge would ever let that in, but this is what we
Oh,
see this guy doing now.
why is he doing that? That has nothing to do with the Karen Reed case.
No, that has to do with someone else's case that you
In
may be handling.
in which he is a witness, not as a police officer, but as an alleged victim. And
Yeah.
he is now investigating that. So you want to talk about conflicts of interest?
He's now intimidating other witnesses.
I You said that, not me,
I
but
said that. I can say that.
you think there's a conflict of interest as it relates to why did the Canton police, within 24 hours because of Kevin Albert, stay on the Karen Reed case?
Hmm.
Ask yourself if you've ever heard of a case in your life, lawyers, anyone else, in which a police officer is an alleged victim, not a police
Hmm.
witness, but as no
Yeah.
different than a civilian,
He's
a victim,
intimidated.
two of them
Mhm.
who are partners and friends and text each other really inappropriate things and then like them.
Yeah.
And you're the one who is going out investigating the case in which you're going to testify as a victim. I've never seen that anywhere. And this is on a hypothetical situation where a prosecutor said, I got to get off this case. Why
Right.
wouldn't the state police do? So you go back to that, you go back to the inverted video, you go back to all the other problems. So you look forward and you say, how are they going to retry Karen Reed based on what evidence? I mean, look what they did the first time and they got nothing. So how is it getting better for them? And it doesn't matter what the online trolls or the people who, if you say anything, their life's obsession is telling you that Karen Reed is guilty and then harassing you if you have the
Well, you're
temerity,
a grifter and I'm a grifter and we grift. That's what we do here.
which
We're
is
not
fine.
talking about facts or anything. I mean, come
No,
on.
I mean, you can, have your opinion and criticize everyone who disagrees and call them all kinds of names and
Under a
harass.
fake name.
Right. That's all lovely and good. But at the end of the day, get back to common sense, which is how is this getting better for them? I
It's
mean,
not.
it's not. In fact, I think it's untenable for them. I mean, look at it this way. Just in the month since Karen Reed got acquitted or not acquitted, whatever the hell happened
Mhm.
with this verdict gate, in 1 month, the following has happened. Okay, Proctor is hanging by a thread and is toast, and the DA has sent out a mass letter, a Brady letter about Proctor. Right, that's
Mhm.
all done. Okay,
Yeah.
Buchanan is under IAB investigation since then. Tully is under IAB investigation since then. This is just in 1 month.
Yeah.
Okay,
Since
so
the verdict, right?
is it better or worse for
Or
the
the
DA
lack of verdict.
in 1 month? It's
Right.
already like that much worse, and it's
And
going to get worse. You haven't even heard from the feds.
the train is still rolling down the track.
They're ready to go. At
They are
least
so ready to go.
that's what they say. I mean, we ought to be able to retry her for murder, but I just think that they're kicking the can down the road, and eventually, it's not going to happen. And I think also if they try to retry her for murder, you're going to get politicians who start criticizing them, and you're going to see more
Mhm.
public outrage. You're going to see more
The
protesting and more.
governor. Maybe the governor could come out and just pardon her. I don't know anything about an August 12th court date for Karen Reed, Chick
I don't.
Eastwater, and I just looked it up and it's not in the court system, so I do not know. You may be confused, perhaps. All right, Mark, I'm going to let you go. I got a bunch of people to thank
Yeah.
here, but thank you. Any closing thoughts? I'll give you the full screen for a sec.
Um, None of it's surprising. There were two things I thought the DA could have done today that would have been reasonable: dump the murder charge or consent to a hearing. And instead, they do the worst thing they should do, which is dive in, all in, and say, this is nonsense. And let's just keep going with murder. And there's no evidence, even though there's plenty of evidence. So, once again, I think the good guys were the defense, and they look like the professionals. They look like the ones who are pursuing justice, and the prosecution looks like they're doing anything they can to obfuscate and obstruct about a woman who may very well have been acquitted, and they have zero concern. And that should shock the hell out of you.
It's
That's disturbing.
chilling, and
Yeah,
we're outraged, and
yeah,
everyone's outraged in Massachusetts. I guess they're saying that maybe Aiden has a court date on Monday. I don't know if that's true or not true.
that's not true.
But thank you. Thank you so much for joining me today. And where are you
Hey,
going to be tonight? Well, first of all, people can find you on Twitter at Bederow Law.
great. We're
And
doing
tonight you're on Young Jerks at what time?
7 o'clock, which
All
will
right.
be more about today and next steps and all that. And
Thank you.
given that it will be Friday at 7 o'clock, don't take the bet on wearing a suit. I assure you, I will not be wearing.
Everyone can switch your vote to hoodie.
It'll definitely be a hoodie.
Thank you, Mark. You're always a pleasure to
Here.
have with me. I appreciate you so much.
Okay.
Thank
Bye.
you. Bye. You guys, wasn't that fun? All right. Sorry, the audio was crappy for the first part, but it is so great to have Mark with us, as always, to give us his insight. Tosh, I wanted to thank you because you put a couple of super chats up, and I did highlight them, but thank you personally. Looks like Bev is thinking about doing the laundry at home. Athena, I'm sorry about this. Please stop posting chats at the top. I can't see the subtitles. Thank you. Usually I'm able to move the subtitles on the stream, but for whatever reason, that news channel that we wound up using because it had the best audio would not let me move the subtitles. So I apologize for that. And also, Blessed Mom from Texas, thank you for this. And I hope you're feeling better from your dental surgery. Tooth pain is the worst. Fairy Raven, Fanning reported to Bev that there was video of the dismissed juror talking about the case, but no evidence was produced. Yeah, I don't know. I don't know what to make of that. But I think, like I said, I think the defense is probably keeping all this in their back pocket. And it could be a motion that we see upcoming because that is a little bit of a conflict for that. If Fanning was in charge of that jury, that's a big, big conflict. St. Elmo's Fire says Weinberg is his name. Made me have tears in my eyes. Eloquent. He was, right? Allie B from Tennessee. Excuse my ignorance, but I'm still confused. If they do retry the case, the only charge would be manslaughter, right? No, as of right now, we do not know. This part has confused this Southern gal. Hello to Tennessee. Tennessee Jed. That reminds me of a Grateful Dead song. They are trying to get the judge to either dismiss counts 1 and 3 based on the jurors they've heard from, or have her call the jury back in to question them to see if they should be dismissed, those 2 counts. So as of right now, we're in a holding pattern, waiting for the judge's decision on this. But the Commonwealth came in via Adam Lally today and said, we oppose all that. We don't think you should call them back. We don't think you should hear this at all. Based on these other cases, which, as Mark and I said, are totally distinguishable, Adam Lally thinks they should just let it go. And we don't think, in the interest of justice, they should let it go. Justice for all, 444. You're so generous today. Thanks again. I'm not sure the Commonwealth won't want to retry manslaughter. They're so adamant and want to waste the taxpayers' money for no good reason. The defense has so much more information. Just saying. Yeah, I think there's too much ego in that DA's office. I don't think Marcy's going to let it go. He's like a dog with a bone. And that is one place where Mark and I disagree. So we'll see who's right about that in the end. We will see. So what do you think? Is this the end or beginning? Terrapin. Today is the death date of Jerry Garcia, which is very sad. Those of you who know. And if you are a fan, you probably remember exactly where you were at the time that you found out that Jerry Garcia died. Thank you, Michelle, for buying me a matcha latte, and also Sandy for who bought me a matcha latte. And thank you to Christina for the Venmo, and Barbara says thanks for keeping up with this, and to Mark also, and Colleen for sitting through Lally's mumbling nonsense once again. And Sandra, how many others did they convince an Emmy to say homicide or suicide? That's a great point. And like we saw that news piece at the beginning, so many defendants are clanging on the jailhouse doors. And I predicted this long ago for cases that they are in jail for that had Proctor as their lead investigator. Or as I said last night on The Glarer, he was demoted during the course of this trial to like customer service rep. No longer the lead investigator, just a case manager. Thank you, George. George also sent a Venmo and says, question. Hold on, I gotta find the question. Oop. If Aunt Bev doesn't rule in the defense's favor to hear from the jurors away from the camera or to probe into their reporting, can they petition the higher court to make a ruling? Yes, it is appealable. George, thank you for that. And the Venmo. And George, and that is why the judge did not set the trial date until January. She said because she was expecting an appeal either way, depending on whichever way that she ruled in this case. And also to thank Suzanne, who says, for the sweetest, most insightful, love you. I love you right back, Suzanne. Thank you so much for your kind donation. And Justin Green, who got in here early for Solo is great. Love seeing you at the Glare and Bederow. Yeah, if you guys didn't watch the show last night, I went on Glare's show and we had so much fun. Like we literally talked. Thank you, Deb K. Last night's live was a good one. for 3.5 hours, and it felt like 10 minutes went by. And there were so many people in the chat who were saying, I can't believe it's been over 3 hours and I haven't turned the channel yet. Crazy. Tosh Quinn, thank you for so many super chats today. And can Karen sue the Commonwealth? It's too early to tell. It's too early to tell. We have to see how this whole thing plays out. But in the end, depending on how it shakes out, she may have a very, very good case against the Commonwealth, the county, the DA's office, malicious prosecution, civil rights violations, and all kinds of things. And Alicia, thank you so much for this. Says she just wants to me to know that they executed a search warrant for some houses, etc., on the missing person, Nikki McCain in Northern California. I'm gonna go look for that. Good. Nikki McCain is still missing. If you haven't watched it, I've already done a stream on this, but I'm going to see if I can find those search warrants. If anybody has copies of them, I would love it if you would email them to me. Put my email on the screen here because that saves me time. Thank you so much for all of you guys who are armchair detectives, armchair lawyers who always want to help with the production of this show. Since it's just me, I don't have a producer or a tech guy, and I could use Craig of the Tiny Desk and a producer. So thank you, Alicia, for that information on the Nikki McCain case. Yeah, go watch it. It was really, really awesome. And to my moderators who keep the chat classy and did again today, thank you so very much for all of your hard work here. I love you with all of my heart. And to my viewers, everyone hit the like button because it really, really, really helps with the algorithm. It helps get this content out there, helps people find Mark and me. And it really helps the channel. And yes, I totally, absolutely, 100% KPT would get Craig a man-sized desk. He can have the biggest desk that he wants. He can have a 10-foot long, 6-foot wide desk, whatever he needs. I know, I miss Craig and his tiny desk too. And we saw the same thing in the Ashley Benefield trial, for those of you who followed that with me. Same thing. Their tech guy, who was also their paralegal, had to sit at a little tiny table behind the defense table. It was terrible. It's not a good look and it's not really fair, but again, nobody asked me. So there's that. So do all the YouTubeish things, subscribe, like, hit the bell so you'll know when I go live again. Let me know what you'd like to do a show on tomorrow. If you want to do some Sarah Boone stuff, if you want to do some Ellen Greenberg stuff, there's a lot of stuff that we could catch up on, but August is typically a kind of a dead court month. There's not really any trials that we can watch, but if you find one, let me know and I'm happy to cover it with you because I do love doing live trial coverage. I think the best. Fancy RPG thinks Proctor has a plea deal to whistleblow from Canada. Thank you so much for coming in here. That would be interesting because his entire career is on the line now. His whole livelihood, everything, his family, all of it. All of it. Thank you, Scott Messerschmidt, and to all my moderators. Love you all. Albert's Bulkhead Doors, Team Brittany, Little Cupcake, Patronus Glow. All you guys are the best. Love you. All right, everyone. As I always say to end every stream, it is so not hard. It is so not hard. Be cool, be kind, be classy. So not hard. Peace out. We're expecting a huge storm here. Hope the internet holds out. I'll see you all real soon. Good night, everyone.